This week on Lewis on the Law, I have yet another great and empowering show for you. I have attorney Matt Goings on with me, and we're going to talk about legal issues facing entrepreneurs.
Welcome to Lewis on the Law.
Powerful beyond measure, and that is the phrase of the day. I have another great and empowering show for you. My name is James Lewis. You're listening to Lewis on the Law. I'm really excited to have attorney Matt Goings on with me from Goings Legal. And Matt is also director of the Georgia Lawyers for the Arts.
Director of Operations.
Director of Operations. Let's get it right?
Yeah.
Director of Operations.
I don't want to take any more credit than due.
You don't want to take any more credit than what's deserved.
Exactly.
Yeah. So let's talk a little bit about the show's not going to be around. I'm going to have Matt back on, and we're going to talk about art and the law, but just talk a little bit about Lawyers for the Arts. I just want to get that out there to my listeners.
Right. So Georgia Lawyers for the Arts is a nonprofit organization. We were started back in the 1970s, and we serve artists of all sorts across Georgia, whether you're a musician, a painter, a sculptor. We've even extended assistance to some models. So whatever.
Some models, like famous models? Like, is there any?
Not necessarily famous.
Okay.
These are more for people, underserved artists. We have an income cap where if you fall below this income level, then you are able to get pro bono legal assistance from any of our attorneys in our network. And so you just pay a membership fee to Georgia Lawyers for the Arts. And then if you have a specific legal issue, we can match you with an attorney who will then work on that legal issue for you for free. You're not paying for the attorney's time at all.
Well, you know that almost every single musician in the world or in Georgia will qualify. I spent my 20s as a quote-unquote professional musician, and let me tell you what, you spend a lot of time being broke.
Oh, yes. We get a lot of artists in, and we've actually had some famous artists come in. I can't tell anybody. I can't tell any names because of confidentiality, but we've actually had some famous artists come in that we have been able to assist because they were wronged in the past and weren't getting what they deserved.
Nice. So let's talk a little bit. You're also in private practice. You are an attorney playing a dual role in life. So let's talk a little bit about your private practice.
So my private practice is Goings Legal. Through Goings Legal, I also assist some creative individuals, but I'm mostly tailored toward assisting entrepreneurs and startup companies that are in the technology field. But any entrepreneur is welcome. Every entrepreneur faces the issues that we're going to talk about today. You may not be thinking about it because you're focused on building your company, building that thing that your company is based around, but these are important issues, and I'm here to educate you on those and think about those things so you don't have to.
Excellent. And before we get into this, I have some really exciting news. I'm going to interrupt your flow here. I was supposed to say this at the beginning, but I'm never really good at these things. This show is now being podcast on every single major podcast platform that you can think of. And I only know a couple of them: Google Play, iTunes, Spotify. But you can go to Lexus and tell Lexus to play Lewis on the Law. And believe it or not, this show will pop up and you can say Lewis on the Law, Matt Goings episode, or legal issues facing entrepreneurs. And me and Matt will pop up. If you're watching videos, Alexa will pop up this video on your television. Crazy enough as it may seem, but that's where this world is heading to. So it's exciting news. I just had to throw that out. Now let's get back into you. It's all about you on this show. It's all about you on this show. Exactly. So what is the first thing that entrepreneurs have to think about here when they're thinking about starting up a business?
So one of the first things that an entrepreneur needs to think about is its corporate formation. We'll talk a little bit about the different types of corporate entities that you can choose from, when you will need to incorporate, what type of entity might be best for you. But early on, you need to think about this corporate entity. There are several different types, one of which is its sole proprietorship. Sole proprietorship just means that you're operating on your own.
That's all about me.
You have no corporate entity. You're just operating as yourself. Each of these things has some benefits and drawbacks to that. So a benefit to the sole proprietorship is you don't have to worry about ever registering this company with the Georgia Secretary of State. You don't have to necessarily worry about these requirements for upkeeping the corporate entity. It has pass-through taxation, so it's not really going to complicate your tax returns too much, especially with the new tax code that has just come out. That's just going to be reported on your individual tax income. Major drawback for sole proprietorship is that you have no corporate entity protecting you. You are personally liable for all actions you take. You are personally liable to any creditors and for any potential lawsuits against you. They can not only come after corporate assets, the money you're making there, but they can come after personal assets because there is no corporate barrier. So while it's really easy to operate as a sole proprietorship, and there may be some advantages early on while you are first working on your product, working on that service, and discovering what you want to do, if you're just exploring ideas, might be okay to stay there. The next would be an LLC, which is a limited liability company. And the advantages of this are, if you're a single member LLC, it really operates exactly like a sole proprietorship. It's just you operating. It has pass-through taxation as well, so it's going to be reported on your personal income. There are some extra forms to fill out for that, but an advantage here over sole proprietorship is doing a Schedule C form where you can put in your business expenses and get tax write-offs from that. So any money you're spending to develop your business or can be classified as business expenses can be written off of your personal taxes. Additionally, you get the corporate veil here. So if somebody sues the company, they can't get at your personal assets unless you've been doing shady stuff and mingling your assets. So if they sue the company, they can only get whatever company assets are available. They can't go after those personal assets. And then you have your different types of corporations. These do not have pass-through taxation. You're going to be paying taxes on whatever the corporation makes, and then additionally, you'll be paying taxes on whatever money you're drawing from the company. When you're paying yourself, you're paying taxes on that. Some of the advantages for having this corporate entity, you're still able to write off business expenses. The C Corp or the S Corp entity is going to be more appealing to potential investors because they are not going to have that through taxation. They are going to be protected from having to pay taxes on those profits or loss from the business.
So this brings to mind what type of entity is best? Does this just depend on your situation? What if you're a small guy just starting out a business? What would you recommend?
So I'm going to give you the typical attorney answer here. It depends. It depends on your situation. As I mentioned, if you're first just exploring this idea, maybe you don't need to form a corporate entity because you're just exploring what you're going to do. You might be writing some code at home or developing a prototype of something. You don't necessarily need a corporate entity at this point. When you're beginning to market your product or are actually taking some business steps, I usually advise clients to form an LLC. And this is not advice to you personally.
Once again, this show does not give out any legal advice. And I have to throw this disclaimer out every now and then because technically we're not allowed to give out legal advice on air. This show is only designed to give you information. So everything Matt is going to tell you, it may sound like advice, but he's only giving you information.
Exactly. So if you're moving into these early company stages, you might want to form an LLC. This is going to provide you that corporate veil, shield your personal assets. You may not have a lot that's that you don't want to put that on the line for the company yet. So it's going to give you this corporate veil. It's going to still have through taxation. You can still make money off of it, and it gives you an entity to operate from. Later on, when you start searching for investors would be really the time you can convert this LLC to a C Corp or an S Corp. I don't think it would be really necessary to become a corporation like that until you're at the point where you're searching for investors. But you may be advised by other attorneys to go ahead and form a corporation, so it's just there from the beginning.
Okay, we're already at the end of our first segment. Time flies by when you're having fun. Exactly. Matt, why don't you give them some contact information for you real quickly?
So you can find me online at goingslegal.com. That is GOINGSLEGAL.com. And you can also shoot me an email at Matthew, MATTHEW, at goingslegal.com.
You're listening to Lewis on the Law, and this show comes to you each and every single week to give you legal information, to empower you, the listener, with information that may help you form a decision, know what type of issues you need to preserve, what to look for in an attorney. If you actually have a serious legal issue, you need to go ahead and contract with an attorney, not depend on the information that you hear on this show and think, oh yeah, I'm ready to handle my own case right now. You can always contact me through my website and I can direct you towards an attorney. There are a lot of them that appear on this show. You can scan through my shows and I let each attorney that appears on my show go ahead and give you contact information for him. If you have an idea or a topic for this show that you'd like to hear on air, go ahead and hit me on my webpage on the last page, the contact page, jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can give me a phone call at 404-610-0075. When we get back, we're going to talk a little bit about corporate documents, and we're going to talk about intellectual property that will affect startups. You are listening to Lewis on the Law. My name is James Lewis, and I have you know what? The law is fun and exciting. And in that vein, I have another empowering, fun, and exciting show going for you today. I have attorney Matt Goings on with me. It's no pun intended. It just kind of happened that way. And I have to tell you, the listeners, that Lewis on the Law has gone worldwide. That's right. We are now worldwide. We're national. I think there's a song that goes that way. It just came to me, and I'll have to play that next time. Anyways, you can pick up this podcast on any of the major podcasting platforms. Of course, you can listen to us on air every Saturday morning at 9 a.m. on Biz 1190 AM. You can go to my website. All of my shows are archived on my website. You can see the videos. You can see you can pick up the podcast. Of course, who needs that anymore when you could just say to Alexa, "Alexa, play Lewis on the Law," and sure enough, it will pop up. If you say, "Alexa, play Lewis on the Law, legal issues facing entrepreneurs," and me and Matt will pop up on your screen. That you may or may not want that to happen. So it's all in your hands now. Don't go ahead and create the atom and destroy the world with it, but take it for what you will. This show is only giving you information. I'm way off the line now. Matt, when we were just left off, we were talking about corporate formation. Let's go ahead and talk about some of the documents, because there can be, you want to form an LLC, you want to form a C Corp. There can be just a jungle of documents. At least that's when you don't know, that's what it looks like from the outside.
Right. So if you're operating as a sole proprietorship, you're not going to really have any corporate documents at that point. These really start coming in.
That makes it easy.
Exactly. It's one of the advantages.
Mm-hmm.
When you move to an LLC, you are able to have, and it's a good idea to have an operating agreement, but here in Georgia, it is not required when you're filing an LLC. The operating agreement is really going to dictate how you are running the business. And this is more important if you are a multi-member LLC. If you have other people who own the company and are operating it along with you, that's going to lay out the relationship, who has what responsibilities. And as you move into the S Corp or the C Corp formation, it becomes necessary to have corporate bylaws. These are required to have. It is like an operating agreement for the corporations. Will dictate how the company is run. It might include the duties of officers and the board members, how the board members are elected, how officers are elected. It's going to be very in-depth and have a lot of information. So it is a complicated document to have, and I would not recommend trying to do that on your own or just grabbing something online, because it's not going to be tailored specifically to your needs.
That almost sounds like one of the disclaimers that you see on I guess I could say Jackass on one of the disclaimers. Don't do this at home, And once again, if you hear it on this show, don't take that as I've been advised by attorney Matt Goings on how to go ahead and do this. So yeah, no, that's not the way it works. Go ahead and go ahead and give Matt a call. Matt, give them some contact information.
Again, you can find me online at goingslegal.com, GOINGSLEGAL.com, and my email is Matthew, MATTHEW, @goingslegal.com.
There can be a legal jungle when forming a corporation, LLC, C Corp, S Corp. Let's get into the alphabet gang. We don't want to do that because we want to talk about something more fun today. We're going to talk about, because you are a lawyer for the arts in a way. You are an art lawyer of sorts. Of sorts. So let's talk about copyrights.
So copyrights is one area of intellectual property that everyone in life actually owns a copyright. You may think that you have to register the copyright to actually own it. Anyone who's ever taken a photo, a selfie, written anything for class actually owns a copyright. So what copyrights do, they protect creative works. Anything that is creative, whether it's a drawing, a picture, a poem, any sort of writing, will fall under the purview of copyrights. So if you're an artist forming a company, all of your art is going to be protected by copyright law. But what if you're in the technology area? You think, what is protecting that? Copyrights actually do protect certain forms of technology. So if you're writing computer software, that is classified under copyrights as a literary work. So if you're writing software...
Computer software is a literary work. Nice.
Yes. What you're seeing on your computer screen, watching this, YouTube, whether you're typing in Microsoft Word or any other programs like that.
Now, is that new in copyright law? Is that new? I think I remember back in law school hearing that there was a debate over that.
There was some debate about infringement of copyright law. There were some early cases where companies were being sued and actually lost for copyright infringement for just booting up the computers because the computer was technically making a copy of the software upon boot up. So the law had to be amended a little bit to catch up with technology. So just booting up your computer or using these programs is not copyright infringement. Whenever you're installing something, you have to click that little I agree box. I'm sure you didn't read all the terms, but what that is...
I'm an attorney and I don't even read all the terms. At a certain point, your eyes just glaze over and you're like, yeah, I want to end on the site or whatever.
And that has bitten me. That's come back to bite me before.
Okay.
But when you're doing this, you don't actually own the computer software. You're just signing a license to use it. And you have to obey these rules that they lay out or else you can potentially lose your license to operate that. So copyright can be an important consideration for a tech entrepreneur. You have your people that are writing the software for you. You're not thinking about how to protect it. You do want to protect it. And that's where an intellectual property attorney like me can come into play. The most common response I get when talking to clients is, and I ask, what are you doing to protect your intellectual property? How are you protecting this? Do you have an assignment agreement in place? And I just get blank stares. They say, what is that?
They're like, what?
Right.
And it almost, and I want to go back to that a little bit because it almost seems like that's an area that would be covered by patents.
Right. So patents.
I mean, I don't want to get too much into patents right now. We're going to touch on that later, but just when you brought that up, I mean, I immediately thought of, is that a copyright or is that a patent?
Right. And there actually is a gray area right now in patents. So software can be patentable under certain circumstances. I'm sure if any of you are familiar with patent law, you're thinking about the Alice case right now. The Supreme Court has kind of interpreted patent law to have some extra barriers to patenting software. But at the pace software moves, a patent, even if it is patentable, a patent may not be the best choice for you. Copyright protection occurs much quicker, and it does not have as short of a time limit as patent law does. Correct. So you just mentioned duration. One of the important things to think about with copyright is how long does this copyright protection last? This copyright protection, in the case of an individual, so any photos you've taken or things you've written, that protection will last for your entire life, plus another 70 years after your death. For companies that have works made for hire or things like that, that protection is actually only going to be a set amount of 95 years from the date of publication.
Okay, so we've talked about code. What other types of works? I mean, it's not just code that's copyrightable. Correct. What other types of works are covered by copyrights?
So there's literary works, which software falls under. There's
the software falls under literary works.
Correct.
I love it. So that's where this world is going.
Correct.
I love that.
So we also have pictorial or graphic works. So if you're a graphic designer, that will fall under copyrights. Videos fall under copyrights. Sound recordings fall under copyrights. So once this recording is done, you'll own a copyright, or one of y'all will own the copyright in this recording, in the show.
Well, technically, I shared this one with Biz 1190. They've marked everything on here.
Right. And in that case, it's a good point there that you're sharing the copyright with it. Copyright ownership can be transferred through contracts. And that's what happened to a lot of musicians back in the early days of the recording industry. They lost control of their copyrights.
Yeah, and they lost control of the copyrights and, more importantly, their money.
Correct. So, yeah, it can cover a wide range of things. And there are actually 4 elements I'll go through real quickly. Questions to ask yourself if you're wondering if something is copyrightable. And the answer to each of these questions must be yes. If any one of these is no, it's not copyrightable. So copyright is an original work of authorship that is fixed in a tangible medium. And original just means that it's original to the author, that you did not copy it from somebody else. Work of authorship just means that a human has to be the one that created the work. You strap a camera on your dog and let it run around, and it captures video. There's no copyright associated ownership.
But wait a minute, that's
you.
such deep art right there. My dog, he's in tune with the flow of the universe, and I mean,
what you could do with that footage is edit that footage into another video, shortened video, where you cut out all the nap time, and that you could own the copyright in that.
You cut out all the nap time, and they spend a lot of nap time.
Exactly. And then the last 2 are fixed in a tangible medium. You can't have one without the other. Fixation just means that it exists in that form for more than a few seconds, and a tangible medium is anything that can be touched. So whether that's paper or an SD card where it's stored, even if you're storing things on the cloud, it's not just in the air, it's stored on servers in some area of the world. So it is tangible.
I love that. You're getting into such a nebulous territory, and we're already at the end of this segment. I've got a million questions I want to ask you about that, so we might lead back in with my questions, but give them some contact information before we leave this segment.
Right, so you can find me online at goingslegal.com, GOINGSLEGAL.com, or shoot me an email at Matthew, MATTHEW, at goingslegal.com.
You're listening to Lewis on the Law, and my show comes on each and every single week. If you have, and I know some of you guys have already emailed me, and I've brought on attorneys who talk about this issue, but if you have a legal issue that you want to hear spoken about on this show, go ahead and drop me a line on my contact page on my website, jameslewislegal.com. You can also email me at james@jameslewislegal.com, or you can give me a phone call at 404-610-0075. And if I don't know enough about your topic, I will bring an attorney on who actually knows something about your topic, and we'll talk about your topic on air. I have attorney Matt Goings on with me. We're talking about legal issues that face entrepreneurs, and we're getting deep into copyrights right now. I've got a million questions I want to ask him, and we're going to get to that when we get back. You are listening to Lewis on the Law, and I have I realized the musical selection, I've stopped myself in mid-sentence, but the musical selection for this show is really heavy. And the last show, it was really light. I wonder if I'm doing something subconsciously here.
I like it.
Yeah, I'm picking myself up for the later show. I have attorney Matt Goings on with me. We are talking about legal issues facing entrepreneurs, and when we last left off, we were talking about copyrights. And before I do that, I have to plug the fact that this podcast is now worldwide and national. You can get it on any streaming medium you can possibly think of: Google Play, iTunes, Spotify, Alexa, whatever it is that you're doing, you can find us. And I have attorney Matt Goings on with me. We are talking about legal issues facing entrepreneurs, but right now we're getting into copyrights. And you said something that really fascinated me. And even if this is already an established area of law, it still fascinates me that computer code is protected under literary works. I mean, it brings a whole new dimension to the fact that a person could say, I'm a writer and I create worlds. I think that's fascinating. And there's not a question in there, but let's talk about infringement and what happens when someone infringes upon someone else's copyright.
So when you own a copyright, there are 5 distinct rights that you earn by owning that copyright. That's the right to reproduction, which is to make copies.
Not to have babies, but
Right.
yeah, okay, got it.
It's copyright babies, basically.
Yeah, okay,
So
got it.
that's the right to make copies, whether they're identical or substantially similar. So it doesn't have to be exactly the same. If it is, it's a much easier case to prove. But substantial similarity just means if you look at these two things side by side, can you tell that one thing was derived from the other? Your second, it's technically two rights. But
Can I ask a question
Yeah.
on that? So, what about Andy Warhol and his Coca-Cola can? Is that derivative, or I mean,
So
did he have to pay Coca-Cola royalties?
I believe there was a lawsuit
Because
over
it
that.
seems like there would be an issue there.
I'm not quite sure about the answer
okay.
to that,
Okay.
but that's going to depend. The Coca-Cola can itself is not necessarily copyrightable. Interesting thing about the Coca-Cola script, when you see on that script was something that they developed and was under copyright originally. But remember, the duration for works made for hire is only 95 years from the date of publication, and it was even shorter at the time that this occurred. So that script is actually now in the public domain. So if you want to use that as a font writing something, you can do that without infringement.
Once again, we're not giving you advice. We're not advising you to infringe or how to infringe. We are only telling you a little bit of information out there.
You may run into some other issues, potentially trademark issues, where someone thinks you're associated with the brand because you're using that script. But technically, that script, that style, is in the public domain, which means there's no longer any copyright ownership attached to it. So we have the right to reproduction, and then there's the right to publicly display or perform those works. So in the case of music, as the copyright owner, you are the only one that has the right to perform those works publicly. There are some exceptions there are some exceptions for, performing and doing cover songs. We won't get into the weeds of that because there's a lot of nuance in there. And then there is the right to make derivative or adaptive works. So if you wrote a book, you're the only one that has any right to write any sequels or prequels to that book, or any adaptation. So a film version of the book, you're the only one that has the right to make that or give somebody else permission to do that. And then the final right is the right to distribution, whether that's selling it or giving it out, whatever you're doing, you're the only one that has the right to do that, with a limited first sale doctrine exception, which only applies to a physical item.
Okay, wait a minute. You just threw out some fancy legal stuff out there. First sale doctrine.
First sale doctrine.
Whenever you get into doctrines, that you got to unpack that stuff.
Right. So that's just an exception to the right to distribution, and it only applies to the physical copies of something. So if I released a CD of music, sold you the CD, and you were like, I really don't like this, the first sale doctrine just lets you do whatever you want with that physical copy of the CD. You can sell it, you could throw it away, you can keep it, do whatever you want, so long as you don't infringe on those other four rights. And you mentioned infringement, so I had to tell you those rights to be able to tell you what infringement is. Copyright infringement occurs when someone practices or exploits any of those five rights without the copyright owner's permission. So if I sell you that CD and you make copies of it and sell it, you have violated the right to distribution and the right to reproduction. So you've infringed on my copyright.
And who does that?
I'm sure almost everyone has infringed a copyright. If you've ever downloaded music,
burned a CD for a friend. I mean, who would do something like that? They're monsters. Burn them at the stake.
Exactly. So anytime you do any of those five things, that is considered copyright infringement. If you were to sue somebody over that infringement, you do have to show two things, and that is there was substantial similarity and that there was access to the work. So you don't have to show that they actually saw the work, but just that there was the opportunity that they had access to that work.
Excellent. So that's getting me thinking, and I know there's some issue when you use people's likenesses and appropriate images. I mean, is that a copyright?
So in that issue, you can have a few little things to look out for, especially when you're advertising or building a website. You don't want to use anyone's photograph without their permission. You may think that using a photograph and giving attribution to the photo, to the photographer or the graphic artist is enough, but it's not. You have to have their permission to use that. Otherwise, it's copyright infringement. And you also mentioned using somebody's likeness. So while a lot of people think that it's copyright, it is not necessarily. It very closely related, but that gets into the use of the person's image or likeness. And it's an important thing to remember is that you can't use somebody's likeness in a commercial manner without their permission. Commercial just means that you're using it in some way that is associated with a product that it looks like they are endorsing that product. So if you take a photograph.
Wait a minute. That was my next advertising campaign. I was going to put Sheldon loves Lewis on the law and have a picture of Sheldon from The Big Bang Theory. You mean I can't do that?
You can't, not unless
There's probably a lot of violations going on there.
There are. So you'd probably run into some issues not only from the actor himself, but likely from the network that owns the rights. Especially if you're saying Sheldon, they're going to come after you for that.
Well, who knows the name of the actor? Is Jim something or another? I don't know the name of that actor. I'm just like, everybody knows who Sheldon is, though.
Right. So yeah, if you're using that, especially if the Sheldon, you might run into a copyright issue there of using that character. Is more likely going to be that public, the likeness there. So commercial manner just means that you are associating that person as if they are endorsing a certain product.
And what if I'm not making a lot of money on this show? Wait a minute, I am making some money on this show, but what if I'm not making a lot of money from this show?
It doesn't matter how much money you're making from it if you're using it with that outside of what you're permitted to do.
Okay. What if I'm making no money on this show? Still no.
Still, you could run into damages there. So with infringement, there are two types of damages you can get. One is actual damages. Let's go back to our music example. I've released my CD. Someone else, you steal it, and you're selling it on the side. Actual damages would be my lost profits and or whatever profits you made from selling that. So that's what I would be entitled to. On the other hand, you have statutory damages, which set a minimum amount recoverable for each infringed work and a maximum. So that window is $750 up to $30,000 per infringing work.
The statutory, that actually gives it some meat and some teeth, it feels
exactly.
like.
But you can only go after statutory damages if you have registered the copyright at the time that the infringement occurred. Remember, registration is not required to own the copyright, but if you want statutory damages, it has to be registered before that infringement occurs.
Okay, so let's talk a little bit about registration.
Yeah, so registration is a formal process where you submit an application, whether paper or online. Online is a lot faster, to the Copyright Office and send them a copy of whatever you're trying to register. And that just, it is stored there, that you're the copyright owner of it. They have a copy of it. It's really just a formal process. And it is required if you are suing somebody for infringement. So if you want to sue somebody over it, it does have to be registered before you can do that.
Okay, so let's talk about timing here a little bit. Does it have to be registered when they've infringed, or does it have to be registered just before they sue?
So it just has to be registered before you sue, but in order to get statutory damages, it has to be registered before the infringement occurred.
Oh, that's it. See, that was a distinction I was trying to get at.
Right.
I'm like, so it's just pays to register at this point.
Right. Depending on what you are. So here's your "it depends" answer.
You're speaking like an attorney again.
Exactly. It's great to talk to an attorney about whether it's advantageous to register something or not. If you're just writing a weekly blog, you're probably not going to want to expend the money that it's going to take to register every blog post.
What if it's my blog? No. Anyways, we're at the end of this segment, and you know, this time is just flying by once again. Matt, give them some contact information for you.
Yeah, you can find me online at goingslegal.com, GOINGSLEGAL.com. And my email is Matthew, MATTHEW, @goingslegal.com.
You're listening to Lewis on the Law. I've got another great show going for you. I've got attorney Matt Goings on with me. If you have a topic that you want to hear on this show, go ahead and contact me on my webpage, jameslewislegal.com. You can email me at james@jameslewislegal.com, or you can give me a phone call at 404-610-0075. When we get back, we're going to talk a little bit about trademarks. You are listening to Lewis on the Law. My name is James Lewis, and I bring this show to you each and every single week. And I have yet another great and empowering show going for you. I have attorney Matt Goings on with me from Goings Legal. And Matt helps entrepreneurs with their issues in the startup. And when we last left off, we were talking about copyrights, but I think we're done with copyrights. I want to talk a little bit about trademarks and branding.
So trademarks are your branding, and they're very important to building a successful company. And I don't want to say to building a successful brand, but having a distinctive trademark really is essential to building a distinctive brand that sets you apart from the competition.
Okay, so what is a trademark?
So a trademark at its most basic is a source identifier. We talked about that Coca-Cola logo earlier. Whenever you see Coca-Cola, you think about where that came from. And there's a lot of, so it's just a source identifier. And a lot of different things can be a trademark as long as they instill in the mind of the consumer that this came from a specific source. So you have the most common one are the names of the companies. So Coca-Cola, John Deere, these are the name trademarks. Then you also have, it could be a designed logo. So the Coca-Cola in that script is also a trademark. The John Deere text with their logo is a trademark. You can also have colors as a trademark. So with John Deere, if I decided I was going to go build some tractors and wanted to sell them, I would be precluded from using the green and yellow color scheme because that is distinctive and that is associated with John Deere.
Seems like you'd sell more tractors, though, if you used it.
You would, and that is the reason you can't do that because it's going to cause customer confusion. People would see mine with that green and yellow, and they would think it was coming from John Deere, but it really wouldn't be, and it would probably be lower quality, so they would be upset, and it would also reflect poorly on John Deere. Sounds can also be trademarked. So if you watch ESPN, SportsCenter, or anything, or you see those IBM commercials, those tones, the little clips, jingles, those can also be trademarks. And then very rarely used, but still able, are actually smells.
Smells?
Yes.
How is okay, now you've got me going here. Okay. Sounds, that sounds like that's starting to get a little bit loopy because, you know, there's all kinds of variations on sound. But smells, okay, I'm going to bite. How are smells trademarkable?
They can be trademarked. So if you're doing a smell,
I mean, you've got to explain this. You can't just throw that out there without explaining.
It is very odd. So a trademark can't be useful in any way. So if you're thinking about trademarking a distinctive smell for like a cologne or something, that you can't necessarily trademark that. What this, again, it has to be a source identifier. So with that, more recently, I think Verizon is actually pursuing one. I'm not sure if they've gotten it or not, but they have devised this distinctive smell that they're going to literally pump into their stores. So when people walking by, you smell this smell and you're like, is there a Verizon store nearby? They just want it to be—
That is incredible.
They want it to be associated with that. So wherever you go, it's going to be the same smell.
That's incredible. That's the first I've heard of that. However, it makes perfect sense when you think about the whole. And when I was in my undergrad, I took a lot of rhetoric and persuasion classes, and you know, a lot of it was about imprinting and
you're creating an experience.
Yeah. And, you know, the Pavlovian experiment of the dog salivating and how you create that impact through sensory input. And they're having the whole, oh, they're missing taste, of course.
Right.
But, you know, they're getting close to the whole sensory impact. If they can get feel, smell, and they're trying to trigger people with those.
Exactly.
With those sensory, with that sensory data, with that sensory trigger. But that's incredible. So, do they have a designer design the smell? And
I'm not exactly
it's like what people really like, grapefruits, or
I don't remember exactly. They did have a description of what the smell was going to be. It was supposed to impart like a sense, basically like a comforting, calm, like a sense of home, or like you belong there.
Okay.
But they're just trying to instill a whole experience with going into their stores.
That's incredible. I would really like to hear an explanation of what these smells are that people are trademarking. I mean, you'd like to think that it's like a cologne or something like that. When you said that, I thought, oh, cologne, of course, or perfumes or something like that. But no, that's not what you're getting at.
Right.
Okay. So what is there more to trademarks on how you protect yourself with a trademark?
Yeah. So as we mentioned with copyrights, that that protection arises out of the creation of it.
Mm-hmm.
It's similar with trademarks. You don't need registration to have protection.
Mm-hmm.
Trademark protection actually comes from using the mark.
Mm-hmm.
So once you start using a mark, you begin having some protection associated with it. If you're once you begin using it, you could put the TM next to it.
Mm-hmm.
That just notifies people that it is being used as a trademark.
Mm-hmm.
You cannot use that circle R, though, until it has been registered federally.
Okay. So how do people register it federally? That leads me to the next obvious question.
Right. So different from copyright law, which is governed by just federal law,
Mm-hmm.
there are both state and federal laws governing trademarks.
Okay.
At its most basic, you get common law rights just from that use,
Mm-hmm.
and it is restricted to the area in which you are using it, that regional market.
Mm-hmm.
You can also file a state registration with the
Mm-hmm.
trademark, and here in Georgia, it's only $15. It's a one-page little document, and that will give you trademark protection just within the state of Georgia.
Interesting.
And you don't have to meet any use requirements other than you're just using it in Georgia.
Mm-hmm.
But to register federally, you have to use it in interstate commerce, which just means that you're using the mark across state lines. Here in the digital age, that's really easy to accomplish because of the internet. The internet serves everywhere. So if you're just because your company is based here in Georgia.
You mean if I have a podcast that's going nationally? And to plug myself.
Yeah.
I should get trademark protected. I should get it registered.
Well, again, you don't have to get it registered. It would be talk to an attorney about whether you need to register or whether you can register it. But to get that
I'm just hoping for some trademark infringement. I'm just like, really? Are you going to infringe upon me? Awesome. I'm somebody.
Right. Well, we can get to that with your name. It actually kind of leads us to a good topic of the levels of protection that you can get, which I'll get to right after.
Yeah, because James
the
Lewis is pretty generic. I mean, there's probably a million of us out there.
So with registering it federally, you have to use it across state lines. So if you're selling a product here in Georgia, but you're offering it for sale online and you're going to ship it elsewhere, it's an offer for sale across state lines. So you have to submit an application to the United States Patent and Trademark Office. It's a much more complicated process than just registering statewide. You have to figure out what class of goods it's going to apply to, because you don't just get the trademark for everything, because remember, it arises out of use. So if you're not using it on hats and clothing and apparel, you're not going to get a trademark protection for hats and clothing and apparel. Only the areas in which you are using it.
Wow, that sounds really complicated and pretty convoluted.
Yes, that's why I definitely recommend having an attorney do your trademark registrations, do clearance searches to make sure that you're not going to be infringing on somebody's trademark by using this or wasting money by trying to file an application when you're not going to get that protection anyway.
Okay, now, before we left off, you said something about strength of mark. What does that mean?
Yes, so there are 5 levels of strength associated with trademarks, and these are just levels of distinctiveness and the amount of protection that they will get. You mentioned James Lewis is very generic there.
You mean I can't get my name trademarked James Lewis?
Correct.
I want no one else in the world using that name.
Right. That doesn't necessarily mean that they can't name their child that. So we've seen some celebrity lawsuits over people copying their names. Like, well, it was trademarked, so you can't do that. That doesn't mean you can't name the kid that. It just means you can't use that name in associated with a product or service or business because it is registered. So
you mean I couldn't name my child Prince or the universally known mark once known as Prince?
I mean, you could name him Prince. You just couldn't, like later on in life, he couldn't start a business and name it like Prince something unless it was very obvious that it was not related to Prince. You still might get some blowback from
nobody knows who Prince is these days. We've gone old school here.
Oh yeah, he's there. So your first level is generic, and there is no trademark protection associated there. So these are things like zipper is a generic mark, thermos is generic. So it is a term. It could have been a trademark before it was generic.
Now, was thermos almost sounds like that was...
It was a trademark. Zipper was as well. But
Zipper was?
It was.
I thought zipper was just a description for that thing that zips up your pants.
Exactly. It used to be the trademark for it. I think I forgot exactly what the technology was called, but it has gone through this process. It had a very different name. So another example would be... Velcro. It's hook and loop technology. And they've actually released a song because people are using it as a generic term. So I'm going to try to get through these other four.
Velcro's become geneticized.
Almost.
Yeah,
they are making sure that people are not using it like that.
Okay.
So you have generic, then there is descriptive. So it can be it really means it's just descriptive of the thing. It's not quite as bad as generic. And then you have suggestive, which is it requires a leap of intuition. You hear something and it takes you a second to think about, oh, that's what they're selling. That has more protection. Then there is arbitrary, which are existing words, but have nothing to do with the product they're selling, like apple. Apple is an existing word. It has nothing to do with fruit, with what they're selling. And then you have fanciful terms. These are made up words, like Xerox. Anything that's made up is going to have the highest level of protection.
And at the highest level of protection, I think that is all. We have so much more fun and so much more to cover, and yet we have to end it here. So, Matt, give them some contact information for you once again.
Yeah, if you have any questions about anything we've discussed, you can find me online at goingslegal.com. That is GOINGSLEGAL.com. And my email is matthew@goingslegal.com.
You're listening to Lewis on the Law. This has been yet another great show. You can always contact me at james@jameslewislegal.com, or you can just go to my website, jameslewislegal.com, or you can just give me a phone call at 404-610-0075. This was the first in a series. Next week, we're going to have another show on startups. We're going to touch on contract issues involving startups. You're listening to Lewis on the Law. See you guys next week.